Hi, my name is Kelsey Atkinson, and I'm a staff attorney with Neighborhood Legal Services Consumer Debt and Bankruptcy team. I'm here with my colleague Michael Massman today. How you doing, Michael?
I'm doing well, Kelsey. How are you?
Great. So today we're going to talk a little bit about adversary proceedings, which are a pretty unique feature of bankruptcy. So could you talk a little bit about what an adversary proceeding is?
Absolutely. An adversary proceeding is like a case within the bankruptcy case itself. So generally, a bankruptcy proceeding is not adversarial. It means a debtor files a bankruptcy petition asking for a judgment that these debts are to be discharged. An adversary proceeding is a case that either the debtor or a creditor might begin in order to clarify or challenge the status of a specific debt or the bankruptcy discharge itself. So again, it's a case within the bankruptcy case itself.
When you say it could challenge the discharge, what exactly does that mean?
When a creditor, for example, begins an adversary proceeding, they might be seeking to cancel a specific debt or cancel the entire discharge. So, one of the reasons that you could cancel an entire discharge is if the debtor made a false oath. So, that's why it's really important that when the debtor's filing their bankruptcy petition, they swear to everything under penalty of perjury that that they're very certain that what they say is true.
So, if a debtor is found to have maybe falsified some information and they end up losing an adversary proceeding, are you saying that they would still have to pay that debt back even though they filed for bankruptcy?
Absolutely. And the scary part is that an adversary proceeding could be about the one individual debt that a creditor is interested in or a debtor. But more importantly, or equally importantly, the creditor can seek to have the whole debt or the whole bankruptcy itself uh, wiped out just because the debtor made a false oath.
Okay, I see. Wow. So, this is really serious if it comes up in a case.
It is. I mean, if you're dealing with somebody who's skilled and knows what they're doing, they will often allege both of those, that a specific debt should be excluded from the bankruptcy, and then on top of that, they will also seek to have the discharge itself canceled.
I think it's important to know and remember, right? This won't happen in every bankruptcy case. This may only happen to a small number of people who file a bankruptcy proceeding. So, what does the process look like when someone files an adversary proceeding?
Yeah, I mean, first of all, you're right. It's pretty rare. Oftentimes it's somebody who has maybe a personal issue with the debtor, or if the debtor's done something really bad, like committed fraud. So yeah, the procedure is really important from the creditor's perspective. You're going to have 60 days to file a complaint with the bankruptcy court, and those 60 days are from the first scheduled meeting of the creditors. It's important to note that it's from the first scheduled meeting of the creditors because those meetings of the creditors often get moved, and the date you need to time it from is from the first one.
And I believe, if I recall correctly, that deadline for the objection to possible discharge is also listed on a notice of bankruptcy that a creditor may receive at the start of the case.
Yeah, and that's a good point. Like, people get those documents, and it's very intimidating. It's very challenging, and they're full of legal language. But it's very important to take the time and do your best to understand that, because usually they inform you of those options. And knowing that language can be dense and challenging, you're welcome to come down to the Bankruptcy Self-Help Center and talk to us about that.
Yeah, definitely. And so it sounds like on the creditor side, right? If you're considering filing an adversary proceeding, you need to be aware of those deadlines. You can't do it anytime you feel like it. But what about for debtors who maybe receive a complaint in an adversary proceeding?
Yeah, so that's going to be treated very much like a standard lawsuit. And so the first thing that means that you have to think about is how much time do you have to respond? And generally, if you're served personally, at least, you're going to have 30 days to respond. And if you do not file an answer with the bankruptcy court within those 30 days, you risk having a default judgment entered against you. Now, that's a judgment where, because no answer has been put in, the court is compelled to fine for the person that filed the complaint.
And what exactly does an answer involve doing?
So an answer, broadly speaking, involves responding to their allegations, and so we like to think of that as two different things. There's factual allegations made against one in the complaint, and so one can respond to those by either stating that they're true or they're false, or that the debtor doesn't have enough information to state whether they're true or false. And then the second component is asserting, broadly speaking, what we call affirmative defenses, which are legal reasons that one might not have committed the allegations in the complaint. So why there was no false oath, or why this debt in specific should not be removed from the bankruptcy.
I think something that we see sometimes in the self-help center is, someone is a debtor in a bankruptcy proceeding and they feel like, this creditor filed an adversary proceeding against them and they are harassing them. And this is so unfair. They didn't do anything wrong. Um, you know, what, what can a debtor do in that situation? Do they still need to respond to the lawsuit?
Yeah, I mean, they have to respond to the lawsuit. It's certainly unfortunate if somebody's feeling harassed, and we don't want to see that happen. But it's the creditor's right to file the lawsuit, just like it's the debtor's right to file bankruptcy. So, from the legal perspective, it's important to respond within the legal rules that are laid down. If a debtor is feeling like what the creditor is doing is too much and unfair, then I would encourage that debtor to either come down to the self-help center, reach out to their bankruptcy attorney or another private attorney, because creditor actions can be a problem. They have to act properly, and if they don't, that can be an issue. And you, as the debtor, might actually have reasons to sue a creditor, for example.
I see. So this sounds like it all can get pretty complicated. So after someone files an answer, what happens with the case? Do these get resolved quickly, or what does the timeline look like?
They can be quick or they can be long. Most cases are going to go on for at least a year or more. It's going to be a lot like your standard case. That means that there's at least three stages, which I like to explain as the pleading stage. That's where we talked about that. That's the complaint and the answer. Then at the end, there's the trial, but there's a whole bunch of work in between that. And the most notable aspect of that is discovery. So that means potentially having to sit for a deposition. That means having to respond to written questions as well. So it can turn into a lot of work quite quickly. And if you're a debtor who's been served with one of these, you should reach out for legal help as soon as possible.
So it sounds like if you receive documents relating to an adversary proceeding, first and foremost, it's really important to make sure you understand the court deadlines and comply with those deadlines. Is there anything else you want to add about adversary proceedings, Michael?
No, I think that's it.
Okay, great. Well, thanks so much for your time. And we do have some assistance available to folks in the self-help center to assist them with adversary proceedings, especially with answers. But that said, these cases are complicated. So we can also provide you referrals to attorneys to assist in these cases as well.